deadly force, period. Are you okay if I tell you the next?
Huh?
The next sentence is under either.
Is it a paragraph? Oh, it's the same paragraph?
Same paragraph, next sentence. Under either of.
Hold on. Under either
of those two circumstances.
This is a separate paragraph.
It's not, it's in the same paragraph.
Is on the second one?
Yeah, if you look right there, Judge, it's right here, I'll highlight, it says.
Oh, I see how they did it.
Yeah.
Okay, hold on, give me 1 second.
Sure.
Okay, under either of those two
circumstances, comma, the defendant had a duty to retreat, comma, unless he was placed in a position of imminent danger of death or great bodily harm, and it would have increased his own danger to retreat, period.
That's it?
Nope, one more sentence.
Go ahead.
If the defendant had a duty to retreat and did not do so before using deadly force, then his use of deadly force was not justifiable. Period.
I want to read it back to you.
Yes, sir.
However, 1, if at the time Othal Wallace used deadly force, he was committing a concealed firearm, that doesn't make sense.
It just committing I guess we could put committing the crime of.
I'll tell you what, if Othal Wallace used deadly force while he was committing the offense of carrying a concealed firearm, or 2, if at the time Othal Wallace used deadly force, he was not in a place where he had a right to be, then the defendant had the legal obligation to use every reasonable means within his power and consistent with his own safety to avoid any danger before using deadly force. Under either of those circumstances, the defendant had a duty to retreat unless he was placed in a position of imminent danger of death or great bodily harm, and it would have increased his own danger to retreat. If the defendant had a duty to retreat and did not do so before using deadly force, then his use of deadly force was not justifiable.
That's correct, yes, sir.
Okay? Someday somebody will fix this. I mean, this is just an absolute mess. Between the three or four statutes that deal with self-defense and stand your ground, and it's just very, very complicated.
Yes, sir.
Now, the one thing is, if you read the paragraph above, I think it's okay.
No, this is the most confusing jury instructions that we deal with, this one.
And then they get self-defense one that comes after that. right, I think that's it. I don't have any others.
Judge, after you get it done, can you just email us a copy, so while you're copying?
I can do that right now,
Okay, perfect, thank you, sir.
but I'm about to copy them.
Yes, sir.
Oh, there's one more, on the verdict. If you go to the verdict instruction, which is towards the end, my line, I can tell you what line it's gonna be. Are you there? It's the third paragraph in. I think the standard has an issue where if you read the standard, it only sort of intimates that they can find him guilty of first degree premeditated or felony, but not both. And I think they have the right to find him guilty of either or both. So I rephrased it. Guilty to the charge of first degree of a law enforcement officer. It is not necessary that all of you agree the state proved Can I just send it to Woods?
Just send it to me, Judge, it's fine. Thank you, sir. Or Mr. Urbana can send it to me.
Judge, if you could, my computer's not juiced up, if you could send it, you're gonna email it, if you could send it to me for this.
Well, yeah, I just want to do it real quick.
Just send it to me, I'll get it to Mr. Rubisco, no worries.
If your email comes up real quick, I think they're all coming up very quickly. Shoemaker is the only one that hasn't come up. Well, he came up then. Larissa did not come up. Okay, I just sent it. Let me know when you receive it, because I got to unplug and go print this. Since I've given you a copy, I'm not going to print a copy for you.
Nope, we're good, we have it.
Do you get it?
Judge.
Okay, I'll be right back.
All right.
Remain seated. I just gotta wait till they get printed. Counsel, did you view the verdict form? Just make sure it's okay.
Sorry.
I'm not either. An independent finding as to each.
Yes,
Right.
and that
unanimity as to each. Like I said, I cited the case law, and that's what I want to go with.
Do you have a copy of that put for the record?
Dillard?
Proposed for,
Um,
I believe I emailed it to you and then.
I can print it and, yeah, we'll file it as a proposed.
Yes.
You didn't file it in the court file?
I sent it as an email, but I don't think that was. Yeah, that I did, but in terms of proposed verdict form, I think that was the email.
Huh? That'll work? Okay. All right. Run to my office, get one, I'm gonna go get the instructions and I'll be back and.
Judge, can I, whenever you're settled in, can I ask one thing?
I hope it's not a change to the jury.
It's not a change, just when you're instructing the jury.
Yeah,
The definition we gave was unlicensed carrying concealed firearm, that's what the caption is.
yeah.
But then when we say that if he's committed the crime, it says the crime of carrying concealed firearm. Can you just instruct him that that's...
It's the same.
It's the same, I guess.
Yeah.
We don't have to change anything, yes, sir.
Yeah. Oh. Just so there's an understanding, yours 132, 118, and 108 were the alternates, correct?
Yes.
Yeah.
Sir.
Yeah. The clerk gets one, the court reporter gets one. We can print more later on, but. All right. Okay, bring the jury in.
All rise for the jury. Jurors present, seated, Your Honor.
You may be seated. Good morning, ladies and gentlemen. Once again, I want to ask you if you, while you were away from the courtroom, did you become aware of any of the facts of the case or any information that relates to the case? Or did you do any investigation on your own while you were away from the courtroom?
Yes, sir.
All right, thank you. All right, each of you has a packet in front of you. These are the instructions that apply to this case. This is your individualized copy for you. I found through experience that some people learn by listening, others by reading, and then others like to have the option to do both. So you have that opportunity to either read along with me or just listen to me. It's entirely up to you. Here's the one rule that applies though. We read together. No one gets ahead, okay? I'm assuming everyone has the packet? All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give to you. Othal Wallace, the defendant in this case, has been accused of the crime of first-degree murder of a law enforcement officer. First-degree murder of a law enforcement officer, which includes premeditated and felony, includes the lesser crime of first-degree murder, premeditated and felony, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jason Raynor was killed by Othal Wallace, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder of a law enforcement officer, or first-degree murder, or second-degree murder of a law enforcement officer, or second-degree murder, or it was manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act, by lawful means, with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if it's used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Othal Wallace may be found guilty of first degree of a murder of a law enforcement officer or any lesser included crimes. There are two ways in which a person may be convicted of first degree murder of a law enforcement officer. One is known as first degree premeditated murder of a law enforcement officer, and the other is known as first degree felony murder of a law enforcement officer. To prove the crime of first degree premeditated murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. Number 1, Jason Raynor is dead. Number 2, the death was caused by the criminal act of Othal Wallace. 3, there was a premeditated killing of Jason Raynor. 4, Jason Raynor was a law enforcement officer. 5, Othal Wallace knew that Jason Raynor was a law enforcement officer. 6, Jason was engaged in the lawful performance of legal duty. An act includes a series of related actions arising from and pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. The word law enforcement officer is defined as follows. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof, who is vested with the authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. Now, this definition includes all certified supervisory and command personnel whose duties include, in whole or in part, the supervision, training, guidance, management responsibilities of full-time law enforcement officers, part-time law enforcement officers or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. The word employing agency means any agency or unit of government or any municipality or the state or any political subdivision thereof or any agent thereof which has constitutional or statutory authority to employ or appoint persons as officers. A person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. An issue in this case is whether Othal Wallace did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Othal Wallace was in fact so provoked and did not cool off before he committed the act that caused the death of Jason Raynor. If you have a reasonable doubt whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder of a law enforcement officer. To prove the crime of first-degree felony murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, while engaged in the commission of resisting an officer with violence, Othal Wallace caused the death of Jason Raynor. 3, Othal Wallace was a person who actually killed Jason Raynor. 4, Jason Raynor was a law enforcement officer. 5, Othal Wallace knew that Jason Raynor was a law enforcement officer. 6, Jason Raynor was engaged in the lawful performance of a legal duty. In order to convict the defendant of first-degree felony murder of a law enforcement officer, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of resisting an officer with violence, the state must prove the following 4 elements beyond a reasonable doubt. 1, Othal Wallace knowingly and willfully resisted or obstructed or opposed Jason Raynor by offering to do him violence or doing violence to Jason Raynor. 2, at the time Jason Raynor was engaged in the lawful execution of a legal duty. 3, at the time Jason Raynor was an officer. 4, at the time Othal Wallace knew Jason Raynor was an officer. The court now instructs you that every Daytona Beach Police Department officer is an officer within the meaning of this law. A person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty. If the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes that such force is necessary. Now, the words law enforcement officer has been previously defined for you at line 140. You should write 140 there. Please use that definition. Employing agency has been previously defined for you at line 150. Please use that definition. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder of a law enforcement officer are first-degree murder, both premeditated and felony, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter. Now, first-degree murder as a lesser included offense. There are two ways in which a person may be convicted of first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, the death was caused by the criminal act of Othal Wallace. 3, there was a premeditated killing of Jason Raynor. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Othal Wallace did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Othal Wallace was in fact so provoked and did not cool off before he committed the act that caused the death of Jason Raynor. If you have a reasonable doubt whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, while engaged in the commission of resisting an officer with violence, the defendant caused the death of Jason Raynor. 3, Othal Wallace was a person who actually killed Jason Raynor. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of resisting an officer with violence, the state must prove the following 4 elements beyond a reasonable doubt. 1, Othal Wallace knowingly and willfully resisted or obstructed or opposed Jason Raynor by offering to do him violence or doing violence to Jason Raynor. 2, at the time Jason Raynor was engaged in the lawful execution of a legal duty. 3, at the time Jason Raynor was an officer. 4, at the time Othal Wallace knew Jason Raynor was an officer. The court now instructs you that every Daytona Beach Police Department officer is an officer within the meaning of this law. A person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. Second-degree murder of a law enforcement officer. To prove the crime of second-degree murder of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, the death was caused by the criminal act of Othal Wallace. 3, there was an unlawful killing of Jason Raynor by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. 4, Jason Raynor was a law enforcement officer. 5, Othal Wallace knew that Jason Raynor was a law enforcement officer. And 6, Jason Raynor was engaged in the lawful performance of a legal duty. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder of law enforcement officer, it is not necessary for the state to prove the defendant had an intent to cause death. The word law enforcement officer has been previously defined for you at line 140. It's the same as before. Please use that definition. The word employing agency has been previously defined for you at line 150. Please use that definition. A person is not justified excessive force justified in the but only to the extent he force is necessary. Adequate providence should not find him during murder of a law enforcement officer. The crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, the death was caused by the criminal act of Othal Wallace. 3, there was an unlawful killing of Jason, demonstrating a divine God. Actions arise pursuant to a single design or purpose. An act is imitating a depraved mind if it is one a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Othal Wallace did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Othal Wallace was, in fact, so provoked and did not cool off before he committed the act that caused the death of Jason Raynor. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder of a law enforcement officer. Possession of a firearm and discharge causing great bodily harm or death. Now, there is in parentheses there an instruction for you that tells you that this particular instruction only applies to second-degree murder. If you find that Othal Wallace is guilty beyond a reasonable doubt of the lesser included offense of second-degree murder, you will next need to answer interrogatories relating to the firearm. You will be asked to answer 1, whether the state has proven beyond a reasonable doubt that Othal Wallace actually possessed a firearm during the commission of the crime, and 2, whether the state has proven beyond a reasonable doubt that Othal Wallace personally carried, displayed, or used a firearm during the commission of the crime, and 3, whether the state has proven beyond a reasonable doubt that Othal Wallace personally discharged a firearm during the commission of the crime, and 4, whether the state has proven beyond a reasonable doubt that Othal Wallace caused great bodily harm or death to Jason Raynor by discharging the firearm during the commission of the crime. Great bodily harms means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. To actually possess means that the defendant carried a firearm on his person or had the firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Manslaughter as a lesser included offense. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jason Raynor is dead. 2, Othal Wallace intentionally committed an act or acts that caused the death of Jason Raynor, or B, the death of Jason Raynor was caused by the culpable negligence of Othal Wallace. Every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Possession of a firearm. Again, in parentheses, there is an instruction that this instruction only applies to manslaughter. If you find that Othal Wallace is guilty beyond a reasonable doubt of the lesser included offense of manslaughter, you will next need to answer an interrogatory relating to the firearm. You will be asked to answer whether the state has proven beyond a reasonable doubt that Othal Wallace personally carried, displayed, or used a firearm during the commission of the crime. It is a defense to the crime of first-degree murder of a law enforcement officer, including lesser included offenses of first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter, if the actions of Othal Wallace constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Othal Wallace does not have the burden of proving that he was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on the justifiable use of deadly force in Florida is as follows. Othal Wallace was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself. If Othal Wallace was not committing any crime other than the alleged first-degree murder of a law enforcement officer or any of the lesser included offenses for which the defendant is claiming self-defense, and if he was in a place where he has a right to be, then the defendant had no duty to retreat before using deadly force. Now, unlicensed carrying a concealed firearm is also known as carrying a concealed firearm. Unlicensed carrying a concealed firearm occurs when the evidence showed that Othal Wallace knowingly carried on or about his person a firearm. The firearm was concealed from the ordinary sight of another person. At the time, Othal Wallace was not licensed to carry a concealed firearm. The term on or about his person means physically on the person or readily accessible to him. The term ordinary sight of another person means the casual and ordinary observation of another in the normal associations of life. A firearm need not be completely hidden for you to find that it was concealed. However, a firearm is not concealed if, although not fully exposed, its status as a firearm is detectable by ordinary observation. A deadly weapon is any object that will likely cause death or great bodily harm if used in an ordinary and usual manner, in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. A firearm means any weapon which will is designed to or may readily be converted to expel a projectile by the action of an explosive. However, 1. If at the time Othal Wallace used deadly force while he was committing the offense of carrying a concealed firearm, Or two, if at the time Othal Wallace used deadly force, he was not in a place where he had a right to be, then the defendant had the legal obligation to use every reasonable means within his power and consistent with his own safety to avoid any danger before using deadly force. Under either of those two circumstances, the defendant had a duty to retreat unless he was placed in a position of imminent danger of death or great bodily harm, and it would have increased his own danger to retreat. If the defendant had a duty to retreat and did not do so before using deadly force, then his use of deadly force was not justifiable. A person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. In deciding whether Othal Wallace was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonable, cautious, and prudent person under the same circumstances would have believed the use of deadly force was necessary. Othal Wallace is presumed to have a reasonable fear of imminent peril of death or great bodily harm to himself when using defensive force that was intended or likely to cause death or great bodily harm to another if A, the person against whom the defensive force was used I made some changes that apparently didn't make. I have a sidebar. using the first defensive force that was intended or likely to cause death or great bodily harm to himself. If A, Jason Raynor was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered an occupied vehicle, or if Jason Raynor had removed or was attempting to remove Othal Wallace against his will from the occupied vehicle, and B, Othal Wallace knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. However, the presumption of reasonable fear of imminent death or great bodily harm does not apply if Othal Wallace was engaged in a criminal activity or was using the occupied vehicle to further a criminal activity, or B, Jason Raynor was a law enforcement officer who entered or attempted to enter the vehicle in the performance of his official duties, and Jason Raynor identified himself in accordance with any applicable law, or Othal Wallace reasonably should have known that Jason Raynor was entering or attempting to enter the vehicle in his law enforcement officer capacity and duties. I will type that up for you, and that will replace lines 602 to 625. That's gonna come to you, okay? I'm gonna begin now at line 627. A person who lawfully and by force enters or attempt to enter another's occupied vehicle is presumed to be doing so with intent to commit an unlawful act involving force or violence. The word vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. In considering the issue of self-defense, we may take into account the relative physical abilities and capacities of Wallace and Jason Raynor to discharge a firearm, whether accidental or not, has been deemed to be use of deadly force as a matter of law. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has a burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence and conflict in the evidence or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness said? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in a law enforcement officer in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules of consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. A statement claimed to have been made by the defendant outside a court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain that it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made a statement, he had been threatened to make it in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of witnesses and have seen in the form of exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or you are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law containing these instructions. Deciding a verdict is exclusively your job, and I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. Now, you may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Now, if you return a verdict of guilty as to the charge of first-degree murder of a law enforcement officer, it is not necessary that all of you agree that the state prove first-degree premeditated murder of a law enforcement officer, and it is not necessary that all of you agree that the state proved first-degree felony murder of a law enforcement officer. Instead, what is required is that all of you agree that the state prove either or both first-degree premeditated murder of a law enforcement officer and or first-degree felony murder of a law enforcement officer. The same rules apply to the lesser included offense of first-degree premeditated murder and first-degree felony murder. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charge. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it reads as follows. If you look up here, I want to explain that second to last instruction I gave you because it's confusing. This is the verdict form I'm showing you here. It says the style of the cases in the circuit court, and then for the 4th Judicial Circuit, Clay County, Florida. State of Florida versus Othal Wallace, and the case number. It reads as follows. Verdict, count 1. We, the jury, find the defendant, Othal Wallace, as follow as to count 1 in the indictment. And there are 4 possible choices. I'm sorry. There are 6 possible choices. It says guilty of the crime of first-degree murder of a law enforcement officer as charged in the indictment. I'm going to go through it, and I'm going to come back. And then the next option is guilty of the lesser included offense of first-degree murder. Then below that, guilty of the lesser included offense of second-degree murder of a law enforcement officer. And then below that, guilty of the lesser included offense of second-degree murder. Remember, in the instructions I told you that second-degree murder carries an interrogatory. So if the verdict is for second-degree murder, then you would have to answer the questions below second-degree murder. And the questions are as follows. Did you find the defendant guilty of second-degree murder? Do you also find beyond a reasonable doubt during the commission of the offense the defendant? And then it says, please answer yes or no. Just put a checkbox. Carried or use a firearm? There's a blank for yes and a blank for no. Actually possess a firearm? Blank for yes, blank for no. Discharge a firearm? A blank for yes and a blank for no. Inflicted great bodily harm or death upon Jason Raynor? There's a blank for yes and a blank for no. And then going on down, as another lesser included of first-degree murder of a law enforcement officer, the next one is guilty of the lesser included offense of manslaughter. Remember, manslaughter has a special question that has to be answered. And if the verdict is manslaughter, then you would have to say, answer the following question. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant carried or used a firearm? And then there's a blank for yes or no. And then the words, so say we all, that tells me that the verdict is unanimous. But I want to explain that word unanimous as it relates to first-degree murder of a law enforcement officer and first-degree murder, plain first-degree murder. Remember, there are 2 theories in this case. There's felony murder and premeditated murder, right? I think we went over this during jury selection extensively. Because first-degree murder of a law enforcement officer includes both theories. Both theories. You can have a split in your vote, and the defendant would still be guilty of first-degree murder of a law enforcement officer. And I'll explain that to you. If 6 of you said, well, he's guilty of first-degree premeditated murder, and then the other 6 say, well, yeah. Yes, sir. And then the other 6 say he's guilty of first-degree felony murder. Then he is guilty of first-degree murder of a law enforcement officer, because collectively, all of you have agreed that he's guilty of first-degree murder of a law enforcement officer under one of or both theories. Does that make sense to you? All right. Okay, I just want to make it clear, because there's alternative theories. You're still outside of the universe of first-degree felony murder. Now, I'm going to give you another example. If 11 of you find him guilty of first-degree felony or premeditated murder of a law enforcement officer, but one of you says, no, I'm going to find him guilty of second-degree murder, then that's not a unanimous verdict, because second-degree murder is not part of first-degree murder. Does that make sense to you? All right, so I just want to make sure you understand that. So I just explained it in the context of first-degree murder of a law enforcement officer. That same explanation applies to first-degree murder, just plain first-degree murder. Because again, that one has those 2, premeditation and felony, okay? It is the job of the foreperson to sign and date the verdict form in ink. Please don't use a pencil. All right, I'm gonna read the last page. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson to sign and date the verdict form when all of you have agreed on a verdict, and then to bring the verdict form back into the courtroom. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or by any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those type of electronic devices into the jury room. Kindly leave those devices in your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote on the note. If you have a question, I will talk to the lawyers before I answer it, and that could take some time. You may continue your deliberations while you wait for my answer. I will answer any question, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. In the event that you wish to review any of the electronic evidence or recordings, please make requests in writing. These particular items may only be viewed here in open court and in the presence of all the jurors. Before I read the last paragraph, I want to go over just the last couple of things. I've just read you the law. Will each of you agree to follow the law as I have read it? Okay. Is there anyone here who can't follow the law as I read it? All right, thank you. There are some exhibits that are going to be going back there. Obviously, one of them is a firearm, and there's live ammunition. I'm going to remove the live ammunition from the firearm, but the live ammunition will remain in the courtroom. If you wish to view the live ammunition, just send a note to the bailiff. While I'm talking about that, there's a note right here that I want you to use if you need to communicate with me. Just write down in here what is it that you need, and knock on the door, hand it to the bailiff. The bailiff will bring it back to me, and I'll see if I can answer your concerns or questions, whatever they may be. 3 of you were selected as alternate. Jurors 132, 118, and 108. If you don't mind remaining in the courtroom when the rest of you begin the deliberations. Logistically speaking, food, it's early in the morning, but I'm assuming there could be a possibility that you'll need lunch at some point in time. If that becomes an issue, just knock on the door and tell the bailiff, we would like to order lunch. That process takes some time, so don't wait till you're starving to death before you knock on the door. It could be another hour before we can get you your food. Electronic devices cannot go back into the jury room. If you have a smartwatch, anything that can connect to the outside world cannot go into the jury room. So leave everything behind into the courtroom, and then the bailiffs will safeguard your personal property here. So don't take any electronic devices into the jury room. I'm sorry? Okay, and they'll tell you where to put those things. I don't know if we have any smokers, but if you do need a break and get out of that room, just knock on the door and tell the bailiff you need a break. Breaks are done collectively. You go outside as a group, 12, if you need a break. But you will not deliberate outside of that room. You'll only deliberate in the room. So if you want to go outside and get some fresh air, he'll take you outside. But don't be deliberating out in whatever they take you for your break. It's not my courtroom, so I forgot my notes of the things that I typically go over. When you have a verdict, this is what the procedure I want you to follow. When you have a verdict, I just want you to knock on the door real hard. I just want them to knock. I want you to knock on the door real hard and then tell the bailiff that you have a verdict. Don't tell them what the verdict is, and then the verdict will come back and we'll collect and we'll prepare ourselves to receive your verdict. The fourth person, whoever that person may be, I'm going to ask you to grab the verdict and just fold it in half and in your hand, bring it into the courtroom. I don't think there's anything else I need to tell you. Yeah, question, same thing. Knock on the door, fill them in here. I believe that's it. In closing, let me remind you that it is important that you follow the law as it is spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. Actually, there was one more instruction that I wanted to tell you about. Your job is to determine the outcome of this case based upon these instructions. You are not to consider any possible penalty as you're discussing these instructions. I want to make sure that's very clear. That is not to be a factor. Thank you very much. Other than jurors 132, 118, and 108, yeah.
Can I get my stuff out?
Yeah, we'll get that for you. Oh, yeah, that's the other thing I forgot to tell you. My previous instruction not to talk about the case is lifted. Now I want you to talk about the case. Take your notes with you into the jury room and then deliberate freely. There are no restrictions on deliberations. We'll stay here as long as you need us to stay here.
All right, jury.
Ring the bell. Counsel, you want to look at the evidence? Oh, I'm assuming there's one that knows how to use a computer in there. Well, they have it in there. They have it in there. So I'll leave it like that. Yeah. Yeah, get your personal effects and come back out. That'll be fine. You may be seated. Thank you. Who's going to take the evidence back there? Folks, can I get you to sit down? We're still in session. Who's going to take the evidence back there? Bring the 3 out. Okay, would you let them know not to remove the firearm, not to remove the zip ties of the firearm? If they need it removed, we will do it for them, but not to do that, okay? Hey, stand by. Back on the record. Well, they're gonna stay here. It did not? Did you stipulate? Okay, mark it as 7. We'll put it on the record in a moment. Okay. Do it at the sidebar. Actually, I'm going to take them with me. Can you take them to the jury room where I'm working out of the 3? The 3, yeah. Take them to the jury room. where my office is. I guess they made that up an office or whatever.
Yes.
Yeah, I'll be over there. Say it again? Yeah, they need to be pulled out of there. Leave your notes here, yeah. Yeah, and the instruction, yeah.
Yeah, I got a little.
I'll meet you there in a moment, okay?
Hard to- this is so fired up a little bit.
Well, just collect them and bring them out. I don't care. Do you have a box? Put them all in a box.
Okay.
Yeah. Okay, let's go on the record. You wanted to,
Yes, Judge, respectfully, I'm going to move for a mistrial. This is one based on two acts that fold together. One, of course, our objection to the court, and to the jury instructions, which reference, the possibility of non-unanimity with regard to the, premeditated murder or felony murder, component of the main charge and the lesser included charge of first degree murder. The other aspect of that same motion for mistrial is I'm concerned that the court, in your review of the verdict form of the jury, talks specifically about first degree murder and the non-unanimity issue with regard to the verdict form. I'm concerned that that discussion with the jury would have the effect of overemphasizing the aspects of first degree murder, be it the original charge or the lesser included first degree murder. So that's the reason for the motion for this.
okay, the motion will be denied. I think I'm bound by the law to use the applicable law, and that's the law of the case, I guess. Not the law of the case, but the law that's currently in place that I have to utilize. And I think the example was used so there's some clarification to it because it is kind of confusing. Make sure that they understand what their job is. All right. Were you able to make the changes? Okay. Then I need to do that right away.
Yes, sir.
Because I need to correct that for them. Now, what's written is not incorrect. It's just very confusing.
Yes, sir.
So, and that was lines. Six, 602. You agree on the evidence?
Yes, we agree to state that.
Okay, take it back. Yeah, let's go on the record still. Mr. Proviska, you indicated that there was a component, something that was not introduced into evidence, which was the Axon camera audit. I think it was on one of the last exhibits, but it wasn't formally entered into evidence. So I'll go ahead and admit it as evidence without objection and then send it back to the jury. Huh? Yeah. lines 602 to 605, 625 in the packet. Please disregard those lines.
of them I've been working on, but it's downstairs now. I can go print it out.
Well, I have mine unless I can make a copy of the states.
I think you have to add the defenses to that.
Huh?
We'd have to add the defenses to that.
Are they not on here? The defenses should be.
Yeah, no, I have to write it on here, and probably take some of this stuff
Yeah.
off.
Is that something you created, Jason?
Yeah, I can,
Could you delete?
I can fix it up. Yeah, yeah.
Okay, this time we'll get on the list.
If I can just take a picture of this, and then I'll.
Okay, let's, still on the record, let's talk about, potential outcomes here. If it's any kind of first degree murder, then we're looking at the penalty phase. No, it's scheduled.
We were discussing, Judge, if possibly maybe on Tuesday afternoon, we can start, we talked to our doctor, he could potentially do a Sunday to evaluate, Mr. Wallace. We could set up depositions, take care of our stuff Monday, maybe Tuesday morning. The only reason is, twofold, is our, doctor's not available Friday, so we pushed it to Friday, he wouldn't be able to testify. And then if we started much later, the following Monday is that through Monday, and also pushing the following week, so.
I think one of yours is 27th. Okay. So, I don't know what you guys looking for.
I was thinking most probably Wednesday morning. I've got 4 doctors, one is from Illinois. I'll probably call them first, because it'll be short, short than the other 2 doctors. And, I don't know the exact one, Lee, they typically go there.
Well, this thing goes first, so this would work.
Well, right.
On Tuesday.
Yeah, we would only have like an hour on Tuesday, possibly at most, and then, I told us we're going to put up, label this, we're fine, even if we didn't hit the post, some of them didn't show up, we would figure it out before.
We didn't bring in George for an hour. And then,
I mean, you can't line up any labels, because
I haven't, to be honest with you, I haven't figured out the last one, most of the doctors, this is such a.
right, I understand.
But I'll certainly give that more thought.
Well, then,
And we've got some actually, just as, I'm sorry to cut you off. We, at least a few of the video last year, just because we're kind of playing it. For the recall, because of the time difference.
sure. So if we did some work on Tuesday afternoon, and then Wednesday, I'm assuming most of your aggravators is part of your.
Yes, sir.
Are you gonna have anything other than your doctor, anything else?
And a video that's about 12 minutes.
Okay, so,
At the shooting where we're gonna be like that.
okay, all right, so, so we can, work Tuesday afternoon. Wednesday, your day, how many days you gonna need?
I would just think that you would.
Is that all you think you'll need?
Well,
I mean, I think realistically you need a day and a half, possibly 2 days, but that's just me.
we think about it, we've got 4 experts. Everything is,
Well,
I mean,
I guess the plan could be again, to put deliberations on Friday.
What I was thinking is worst case scenario for Mr. Wood, we can get through all the witnesses, and then we just put up our doctor on Thursday, we're a little late, get him done, we'll put up our final doctor, who's the radiologist Friday morning, which is much shorter. We can go into closings on Friday morning and.
So we're talking about mixing in your,
Only if we had to, if some, we were pushed crazy if we had to, but most likely not, Judge. We would be able to, Mr. Wood can go, let's say, Thursday afternoon, let's say 3 o'clock, we'll put up our doctor till 5 o'clock, then we only have a very small radiologist on Friday morning, if we had to. If it wasn't running fast, we have it ready, but I'm just playing out my mind how it'll go.
it's like giving the doors a full day.
Question already? Or verdict? Question or verdict?
Okay, so I'm not telling the plans Tuesday afternoon for now.
Sure.
Okay.
we do need to at some point to take a break up in those. And that will require, I think, Megan's testimony as well as our litigation specialist, won't take long.
evidence, exhibit numbers, and description, and we allow to play content from the flash drive given to us as evidence, similar to the content in the agreement. Yes, it's just basically referencing to, yeah.
You had mentioned that they had to watch something out here with everybody present.
I think what I meant to say is that they need a bigger TV. That's what I meant to say. I didn't say that, but
Does their TV have a DVD player?
It does, and flash drive.
it's on the wall. And the answer then.
She's-
All right, so now we have a plan, okay? We're gonna go off the record.
Tuesday afternoon, Your Honor?
record. There's 4 questions here. At what point legally does a law enforcement interaction transition from freedom to detainment? Question number 2, can a law enforcement officer legally detain someone without first telling them why they are being detained and why? 3, is the parking lot at 133 Kingston where the shooting occurred considered private property? 4, can a person transport a firearm they own between their car and a parking lot adjacent to their residence if it is holstered and in their pocket? Is this considered concealed carry? All right, we'll take them one at a time. Let me write the answers. What says the state to question number 1?
Your Honor, I don't think that we can answer any of it.
I think question number 1 has an answer, a legal answer.
We went through this with the instructions, I think, Your Honor, and through the trial. I don't think they should receive another instruction. I would have a question.
Okay, what says the defense?
Your Honor, with respect to questions number 1 and number 2, this was precisely, anticipating this was precisely the reason why we've been fighting so hard for our motion for special and jury instruction. So I would renew the motion we would renew our motion for special jury instruction. We believe that what we submitted is an accurate statement of the law. It's certainly something that is assisting the trier of fact in the determination of the case. It's absolutely a relevant and central point in this entire case, which we've noted our assertion that it should be out there. I would say this affirms the basis of our motion that this is a central issue of the case and the jury needs some assistance in determining this issue, which is at the heart of the factual dispute and the legal dispute in the application of the defense instruction. So as to questions 1 and 2, we would reassert our motion for special jury instruction.
How does your instruction answer question number 2?
I think it would at least provide some parameters in terms of the legal obligation of a law enforcement officer and a citizen in the certain situations that we described. So while my response to the information would be just the jury instruction, how I think that the jury would be assisted as to question 2 would be if they have some parameters in which guide the encounter. I think it would help them resolve whatever factual or legal issue they're working at as to count 2. If they knew what the consent or encounter was, a probable cause stop, what can and cannot a citizen do, I think there could be a robust debate allowing them to answer that question.
Your Honor, that's not the law in this case. That's not what the law, the instructions are for them to consider in this case.
It says, at what point legally does a law enforcement interaction transition from freedom to detainment? Well, I think that's easy, when the person is no longer free to leave.
I think there was a discussion about that, Your Honor, and there was testimony and argument about it. And there is a jury instruction that says it doesn't matter. I mean, it's not relevant to their decision.
What jury instruction you're referring to? The one we gave?
The ones that we gave, yes, sir. Those are.
I left my laptop in my office. Do you have the jury instruction?
I've got them right here, Judge.
Yeah. Is it in the self-defense?
It's on, I'm looking on page 4. I would say first where it says the person is not justified in using force to resist an arrest by a law enforcement officer, to resist law enforcement officers who engage in the execution of the legal duty, and then it sets the standard if. what the conditions are. If they're in good faith and reasonably appear to be a law enforcement officer. That's the crux of the matter. That is the law and that is the instruction. Not whether or not they were detained, not whether or not they were arrested. And then it goes on to talk about excessive force as a means to overcome that presumption.
Oh, thank you.
Your Honor, I would also say, if the court was considering answering this question as you indicated, then the state would be requesting an additional instruction that says that even if the detention or the arrest is unlawful, that they still cannot resist. So it puts you right back in the same position you are now.
That would be inconsistent with the law.
No, it's not inconsistent with the law. Resisting officer without violence, it's different. Resisting with violence, you cannot resist with violence on an illegal detention as long as there's good faith and they know it's an officer. That's the law.
With that, you're talking 7.
776.05.
I thought 776.051 is what you're arguing.
1 and 2.
But that's what's here.
Yes, Your Honor. And I'm saying if the court was inclined to say to the jury, when you're not free to leave, then necessarily we would have to ask the court to say, but that in other words, but it doesn't matter, you cannot resist an officer with violence, even if the arrest or detention is illegal.
I don't know in what context they're asking the question, whether it be on
No, that's a dangerous thing too, Your Honor.
in the first degree,
Your Honor,
premeditated first degree felony murder, second degree murder. I don't understand the context, but I need to try to answer the question.
Your Honor, I think that to move beyond, if the court's not inclined to give our special jury instruction, which, again, if the regular instructions are not adequate, that's when a special jury instruction can come into play. I think by inference we can conclude that that is what is going on here in the deliberations. I disagree with the assertion, which has been the hotbed issue in the case. The state is representing that basically in no circumstance can force ever be used against a law enforcement officer, but in the very same law that Mr. LaRue has decided, there are qualifications to that. If there's a lack of good faith, or if there's an unlawful duty, or if there's excessiveness, and what a better way to make a determination of that than to provide the jury with a guide as to when an officer may detain somebody and what a citizen's rights are in accordance with that particular citizen encounter. If the court's not entitled to give the special instruction as proposed, then number one can precisely be answered under black letter law in our state, which is that at what point in time can a person be free? What time is the transition? When their freedom has been restricted, when a reasonable person in a similar situation will believe that they're not free to leave. That testimony has come in the trial. It came in through Bedard, and it also came in through Denardi. So I don't believe that it would be providing the jury something that's outside of what they have already received, and the factual statement on the record is also consistent with the law. So at least if we want to tackle one issue at a time, our next offer to the court would be to answer it that way, which is whenever a reasonable person would believe that they are not free to leave would be the answer to number one.
And Your Honor, there was also testimony that you couldn't resist with violence, even if the detention, even if it was unlawful. So you can't have your cake and eat it too. If you're inclined to find that when somebody's detained, the jury still needs to be reminded that that is not, that does not defeat the case law and the statute that says so long as you're acting in good faith and reasonably known to be a police officer, you cannot resist with violence.
So then, Judge, at what point in time can the court, can the jury have a legal guide as to what is or is not good faith? Because what I think is very short-sighted is...
I don't have to define that.
I don't... What I'm getting at, Judge, is if the jury's obviously struggling with the issue of when this became a detention and whether Raynor had an obligation to give Wallace certain information. So it's not the case that you can, under no circumstance, use force. If there's an assessment of good faith and it transforms to bad faith, then you can use force. And one issue that they can consider in determining bad faith is whether this detention was improper.
Okay.
And again, Your Honor, for the further legal support would be for the many cases that say if a person is being subject to unlawful force and they resist unlawful force, that is not a lawful execution of a duty. And you can't be convicted of battering a law enforcement officer or resisting with violence in certain situations in that regard.
But I remain convinced that you cannot use deadly force to resist an unlawful force unless deadly force is being used against you, I suppose. I mean, that's been my ruling consistently.
But, Your Honor, I respectfully, I think that's inconsistent with what the law says is that if you have a reasonable belief that imminent deadly force is being thrust upon you, then you can respond in kind. The analysis is if there's bad faith, if there's unlawfulness, if there's excessiveness, then you would transform over to the regular self-defense or stand your ground parameters.
The danger is putting too much focus on one aspect of the case and then them ignoring the rest of it. That concerns me.
I agree, Your Honor, but I think the heart of the matter here is exactly what we are debating here. I think this is the central issue of the case. The entire presentation of the state's evidence was justifying the appropriateness of the encounter through 3 different theories. So if there was such a plain presentation, we wouldn't be having this dispute. It's disputed as to just the basic 1-second interaction here. Why was he there?
Well, if we're to answer question 1 as you want me to answer it, at what point legally does a law enforcement interaction transition from freedom to detainment? The answer would be when the person is no longer free to leave. Question number 2, can a law enforcement officer legally detain someone without first telling them why they are being detained? The answer would be yes.
I would agree with that.
And then they say, and why? Well, because it's the law. Question number 3, I can't answer. That's a question of fact that I cannot answer.
We agree with that.
Question number 4, can a person transport a firearm they own between their car and the parking lot adjacent to their residence? If it is holstered and in their pocket, is it considered concealed carry? I'll just point out to the concealed carry instruction. That's the law.
Your Honor, could we have a moment to perhaps look at the 790 statute about the definition of securely encased? I could be completely wrong about this, but I just would, maybe the court could. I feel like in the definitions of 790, there might be some definition of securely encased or encompassing the situation. I may be confusing it with transport definition of controlled substance, but I think if we could look at 790, that might help us.
And I looked at it. You certainly can look. But all I found last night, Judge, in reference to this, is when you buy a gun from a gun dealer, you're able to transport it from your home, from the store in your car, and from your car in your home, as long as it's unloaded and securely sealed with some packaging. I could not find anything else in reference to carrying a sealed firearm. So you certainly can look and search. I didn't find it. I might have missed it, but.
There's a definition for securely encased. There's a definition for securely encased.
What's that definition, Aaron?
Means in a glove compartment, whether or not locked. Snapped in a holster, in a gun case, whether or not locked. In a zippered gun case, or in a closed box or container which requires a lid or cover to be opened for access. 790.001, subsection 15.
I don't know if that gives us much up there.
Okay. All right. This is what I propose. Question number 1. To the question, I'll incorporate the question into the answer. Well, I'm just going to leave it like it is. It says, at what point legally does a law enforcement interaction transition from freedom to detainment? When a person is no longer free to leave. That's the answer. 2, can a law enforcement officer legally detain someone without first telling them they are being detained? And why? Answer. A law enforcement officer can legally detain someone without first telling them that they are being detained. That is the law. 3, is a parking lot at 133 Kingston where the shooting occurred considered private property? The question is a question of fact which cannot be answered by the court. 4, can a person transport a firearm they own between their car in a parking lot adjacent to their residence if it is holstered and in their pocket? Is this considered concealed carry? Please refer to the jury instructions on unlicensed carrying a concealed firearm. Yes? Okay, I'll go print it, show it to you, and then send it back to them, staple questions, okay? Back in a minute. I don't know. Say it again?
I think what the law says is a person is detained when a reasonable person in the same situation would feel as though they are not free to leave.
You want me to add the word the reasonable part of it?
I believe that is accurate with what the law is.
What's this estate?
Your Honor, I think it is a reasonable standard.
Reasonable standard, I
It's a
understand.
subjective
I'm trying to make it as simple as possible for them.
When a reasonable person would not feel free to leave,
Okay.
under the circumstances.
Yes, sir.
When a reasonable person feels that they are no longer free to leave. That's a standard. Okay? All right, I'll go print it again. Counsel, come up here. This is what I'm going to give him. Staple? Sorry? That's what they fill. They only have one at a time. Extra? No. Yeah. I never. So this is number 2. The one that they already, I took care of, this would be number 3. We are in recess until the jury knocks again. All rise for the recess.
Good enough.